I recognize the honourable member for Nevis 9.
Madam Speaker, I rise following on the very useful submissions of the Honourable Attorney General to lend my support to what I believe is a critically important piece of legislation, the Nevis Island Administration Civil Proceedings Bill 2023. He has, in a very erudite way, explained why we are here. But if I can take a moment just to provide some context or further context for the public, and to say this, that the Nevis Island Administration is a creature of statute. And it is a creature of, forgive me, let me start again. The Nevis Island Administration is a creature of the Constitution. And that Constitution, as we have heard, dates back to 1983. And therefore, the Nevis Island Administration, and I believe all who understand and have worked with the Nevis Island Administration in the public sector and in the private sector, have accepted, as a matter of course, that the Nevis Island Administration has the power to sue and be sued. In fact, Madam Speaker, at Section 106 of the Constitution, which by its own terms is a supreme law of St. Kitts and Nevis, it makes it abundantly clear, and I quote from Section 106, the administration, meaning the Nevis Island Administration, shall have exclusive responsibility for the administration within the island of Nevis in accordance with the provisions of any relevant laws of the following matters: airports and seaports, education, extraction and processing of minerals, fisheries, health and welfare, labor, land and buildings vested in the Crown, licensing of imports. I believe it is important that the public and the Parliament are aware that Section 106 grants exclusive responsibility. And I agree entirely with one of the positions put forward by the Honourable Attorney General, that it would seem obvious that if you have exclusive responsibility for something, then part and parcel of that exclusive responsibility has to be the ability to sue and be sued. Let me use a practical example, Madam Speaker. The Constitution, the Supreme Law, gives the NIA, Nevis Island Administration, exclusive responsibility for airports on Nevis. Let us say that the NIA, in the exercise of that exclusive responsibility, enters into some contractual arrangement in relation to the airport. One would expect that it has that authority, and naturally arising from that contractual commitment, it has the authority to sue or be sued under that contract. It follows, and it is said that things that are obvious need not be expressed. It also, under our Constitution, we have that notion of it being the primary law in the country. It is the standard against which all other laws are measured. Basic Constitutional Law 101. That any law that comes into conflict with our Constitution is void. And we have what is referred to as a pro tanto effect. Simply means that if it's not void in its entirety, it's void to the extent that it conflicts with the Constitution. So the starting place always is the Constitution. Now, why have I bothered to perhaps state the obvious? I have bothered to state the obvious because for years, the Nevis Island Administration has sued and has been sued. And there was never an issue. Throughout all these 40 years of independence, there has never been an issue of the NIA suing or being sued. I have this morning gone to the Eastern Caribbean Supreme Court website where judgments are settled. I see a judgment there dating back to 2006, 3rd of April, in the matter of the Nevis Island Administration against La Copropriété du Navire et al., a case that I myself was involved in when I was young. And that was a matter that went all the way to the Court of Appeal. No issue. In fact, the decision from the Court of Appeal, the single judge, Justice of Appeal Barrow, as he then was, he's now at the CCJ, Caribbean Court of Justice. That decision has become the leading decision in the region on the issue of relief from sanctions. It's been cited everywhere. Who was the party? The Nevis Island Administration. Went all the way to the Court of Appeal. Cited in every textbook as the primary case, the seminal case on the issue of relief from sanctions. No dispute as to the legal standing and ability of the NIA. That was in 2006. I found another decision, Choice FM, against the Nevis Island Administration. A decision of Master Fidela Lincoln. What did that deal with? Breach of contract and damages, civil matters. That was a decision delivered 14th of April 2016. No issue. I went again. I found Wingrove Wilkerson and the Nevis Island Administration. Delivered 17th of February 2020. Just 3 years ago. A decision of Mr. Justice Ventos, and that was a claim in damages for negligence. Again, a civil matter. I use these 3 decisions because I'm pretty sure if I continue to search, I would find countless others. But I use them to demonstrate that the issue of the standing of Nevis and the Nevis Island Administration to sue or be sued was never, ever in question. It therefore came as some surprise that in a matter Ocean Reef Resorts Limited and the NIA, that the Court of Appeal, in a decision delivered, I believe it was in August of 2022, August 17th to be precise, that the Chief Justice, Madam Justice Pereira, with whom her colleagues in the full court, Mario Michel, Justice of Appeal, and Gerard Ferrara, KC, Justice of Appeal, acting, agreed that the NIA had no standing to sue or be sued in civil matters. That took everybody by surprise, because it turned the law as we knew it for all these years on its head, and it introduced novel considerations that had not hitherto occupied our minds. Madam Speaker, I believe that it is relevant for me to point out that the issue of the juridical nature of the NIA and its ability to sue or be sued was not a live issue in this case. This case involved a simple question of a default judgment that had been entered by Ocean Reefs against the NIA and whether or not that default judgment should be set aside. That was the issue. The learned Chief Justice in the Court of Appeal made the determination that the court wanted to look at this discrete issue of the authority of the NIA to sue or be sued, and invited counsel to make submissions. I'm advised, and based on the judgment, that counsel in that matter, Mr. Terence Byron, assisted by Rhonda Niswick Brown for the NIA, Dr. Henry Brown, KC, for, I imagine it was Ocean Reefs, and the Attorney General was represented by Mrs. Simone Bullen Thompson, who is our Solicitor General. Now I want the Parliament and the public to understand that this issue never rose on the face of the proceedings, and therefore one may argue was not necessary for it to be determined in order to answer the question that was actually before the court. The court decided it wanted to examine this issue, invited submissions from counsel. And what is interesting is that all counsel agreed that the NIA had standing to sue and be sued. All. So on all sides of the issue, there was consensus from the lawyers that the NIA had standing to sue and be sued. And one could understand that because I've just listed just 3 authorities to you, going as high as the Court of Appeal, where that issue was moot. It was never even a contemplation. And so, again, one could understand the surprise that the Court of Appeal opted to ignore all that had gone before. Ignore decisions in which the NIA had been involved as a litigant, decisions from the very Court of Appeal, and ignore the submissions of all counsel before the court on the Ocean Reefs matter on this discrete point, and then came up with its own decision. And that decision was that the NIA had no authority. I thought it was interesting to look a bit at the judgment, again to give context as to why we're here. Paragraph 13, Court of Appeal acknowledges that Section 106 of the Constitution outlines the matters for which the NIA has exclusive responsibility. And I have referred to those at the beginning of my short speech to the Parliament today. In paragraph 16, the Chief Justice, speaking for the full court, opines that there is nothing in Section 106 of the Constitution which imbues the NIA with legal standing to sue or be sued in respect of land and buildings vested in the Crown, or indeed in respect of any other area of exclusive responsibility. Now, that is an interesting observation, because it means, on the one hand, you're giving a man exclusive responsibility in his home, but on the other hand, you tell him if anything goes wrong, you must come to Basti and find the AG and beg the AG to bring action for you. Well, that doesn't look like exclusive responsibility to me. It's an odd conclusion. And I hasten to say that I'm looking at the judgment, not criticizing the court, of course. But it is a curious conclusion to arrive at, that the supreme law gives exclusive responsibility for a matter. But the court then, having not been invited to opine on it, decides to opine on it and determines that exclusive doesn't really mean exclusive. And the curiosity is further compounded, because if this decision is taken to its logical conclusion, it means, as the Honorable Attorney General has pointed out, that the federal government and the Office of the Attorney General can be dragged into matters of which they know nothing. Because the NIA is in Nevis operating on 106 of the Constitution, saying that they have exclusive authority in these areas, making decisions, cabinet is meeting and deciding this is what we're going to do. And then when something goes wrong, the Attorney General's office gets sued. And the Attorney General says, well, what is this? I don't know anything about this. I've never heard of this matter. That is what has been created by the Court of Appeal decision. So you had a situation which for decades worked well, no issues. And then the Court of Appeal intervened, and this is now the result. And see what the Attorney General has said. People now agree with the NIA, who decide they're going to sue the NIA. Nevis now has to come to Basti for fiat. And all fiat means a big word to mean permission from the Attorney General. But how then is that exclusive or responsibility on the part of the NIA? Now, it's not for me to suggest what should have happened in the Court of Appeal. But there is a notion, harken back to my years in law school, that talks about judicial restraint in relation to constitutional matters. And if I understand that doctrine, it suggests that where something is not necessary, then the courts generally would shy away from making profound statements on matters that are not necessarily before them. And I am not certain that the Court of Appeal really understood the chaos that could ensue from this judgment. For example, the NIA borrows money. In fact, we owe National Bank and those banks a lot of money. What if tomorrow we said, well, we can't be sued and we can't sue? National Bank, we're not paying. What National Bank going to do? Sue the AG? And when they sue the AG and they get judgment, who going to pay? The NIA? But we know about the AG, we didn't instruct the AG. These are some of the practical matters. The NIA employs people. We have a whole public service in Nevis that is employed by the NIA. Thousands of people. If one of them has an issue with the Nevis Island administration as their employer, you're telling them they must come back here to sue the AG? The AG don't know about them. They're not employed to the federal government. This is the whole horse and buggy that was run through the Constitution by this decision. And that is why I'm persuaded that the court did not take into account the implications of what it was saying. And in essentially overruling decades of authority, it did not contemplate, well, what does this mean for the functioning day-to-day of the Nevis Island administration? And what does it mean for the federal government and the Attorney General? In essence, this is telling me that before I as Premier could take a decision to employ somebody or to issue a contract in Nevis, I should call the AG. I should discuss, AG, here's what I want to do. AG, if something goes wrong, is you they're going to sue? The AG has every right to say, well, you're not paying me. Why should I be taking instructions from you, Premier? You have a legal advisor in Nevis. That's the chaos that I talk about and has been created by this decision. Now, what then is this legislation seeking to do? This legislation is really seeking to correct the mischief that has now been created in terms of the practical and legal implications of this judgment. And in a real way to restore us to what was prior to the, when did I say the judgment was? August 17th, 2022. It's less than a year ago. So prior to August 17, 2022, we had an established, well-known, well-respected approach to these matters. And this legislation, therefore, seeks to reset and really to put us back to what was and what had always been accepted. Now, one would have thought, Madam Speaker, that if there was a contest between the clear implication of the Constitution through 106, which, as we recall, is a supreme law, and any other law inconsistent with it is void to the extent of the inconsistency. One would have thought that if the Crown Proceedings Act was then to be measured as against the Constitution, if any one of them had to give way, it must have been the Crown Proceedings Act. And it therefore would have been open to the court to say, the Constitution does not make us express provision that the NIA has the power to sue and be sued in civil proceedings. However, it follows as a matter of course, as a matter of logic, as a matter of necessity, that it has that authority. It also follows the course of years and years, decades of jurisprudence on the matter. That is what one would have expected. And therefore, if there was a perceived conflict between that and the Crown Proceedings Act. The Crown Proceedings Act is ordinary legislation. It is the Crown Proceedings Act we should have given way, not the Constitution. We should not have been told that the Constitution must be amended or something must be done. It is the Crown Proceedings Act which should have been found to be deficient. And I'm happy that the history of the Crown Proceedings Act has been given today. Because what it says is that the Crown Proceedings Act predated the Constitution. It therefore means that when the framers of the Constitution put that document together in 1983, that the Crown Proceedings Act was already in existence. It therefore has to be read subject to the Constitution as supreme law, not the Constitution read subject to the Crown Proceedings Act that is put in the cart before the horse. And one would have thought that these considerations would have impacted the Court of Appeal. But we are where we are. We have a decision, and the only way to remedy this situation, one, was to go to the Privy Council and to invite the law lords in London to set aside this decision, to say to them that the Court of Appeal fell into error, some may say egregiously so, and that they ought to set the matter right. The other option is to do what we are doing today, to come to the Parliament and to seek, by way of amendment, to make it clear that the NIA has the power to sue and be sued. And that, Madam Speaker, is why we are here. Madam Speaker, the choice then was further appeal to Her Majesty in Council, His Majesty in Council, forgive me, Privy Council, or through legislative amendments. We have come, therefore, via the route of legislative amendment. And the provision, the legislation that is proposed is the Nevis Island Administration Civil Proceedings Bill 2023. The Honourable Attorney General has taken us through the provisions, and I don't think that any value is added through repetition. But the important aspect of that is to answer two fundamental questions. One, whether the NIA, Nevis Island Administration, can sue and be sued in civil proceedings, and this seeks to answer that question in the affirmative, to say yes, it can be done. In fact, at Section 3, it says the Nevis Island Administration shall have the power to sue and be sued in its own name. One would have thought it was trite law, but belts and braces. We're trying now to make it, as they say, ex abundante cautela, out of an abundance of caution. We're saying that it should now be a matter of substantive statutory law. And then the second question was the service of documents, which really was the question that arose in the Ocean Reefs decision, you know. The Ocean Reefs decision case issue was all about whether the documents had been properly served. The Court of Appeal did not have to go any further than that. It just had to say, yea or nay. That really was the issue. Instead of that, we had a whole constitutional exposition, which resulted in a near constitutional crisis in my view, as to how this country functions and how the two entities function. So, this law, this legislation, deals substantively with those two issues. Can the NIA sue and be sued? Yes. And who will you serve when you sue the NIA? And it tells you. You serve the legal department, or where an officer is named, you serve that officer. Simple, clean, and hopefully final. And I want to go on record to thank the Honourable Attorney General, because his office and the legal department in Nevis would have worked collaboratively to come to a solution and to come to a resolution, might be the better word, of this issue, to extricate the office of the Attorney General from matters really and truly which has nothing to do with the office of the Attorney General. and to ensure that the Nevis Island administration has now the express authority from what one would have expected to have been implied, that if you have exclusive responsibility, then you must have the authority to enforce that and sue or be sued. And as I have already pointed out, the practical implications of doing otherwise would really be disastrous in terms of how we function, both at the federal level and at the level of the Nevis Island administration. Now, I know that there is another bill to come, but again, that will come when it comes, the Crown Proceedings Amendment Bill, and that again is just for the belts and braces, Madam Speaker, to make sure that we put this issue beyond doubt. I should also add that this decision has created a lot of confusion on the island of Nevis. It has stymied in a very real way the ability of the NIA to function. It has brought into question contractual commitments and obligations that the NIA has incurred. It has raised the fundamental issue of whether the NIA itself can go to court to enforce certain contracts and commitments. It has raised, as I pointed out, the issue of our debt and how that debt is to be addressed. And so there are fundamental practical reasons why we had to come today. Some may say that we have come too long after the fact, but I say we have come when the legislation is ready, and that we are satisfied that we are now here and we have to address this, and to address this in a direct way. The Honorable Attorney General raised an overarching point, and that has to do, of course, with the proposed constitutional review that will happen. And he's absolutely correct that we are hopeful that after 4 decades of talk, that we would finally have an opportunity to revisit the 1983 Constitution of St. Christopher and Nevis, and to determine what, if any, changes should be made, what, if any, clarity is necessary. He cites, I believe, an example in Tanzania. The only thing I didn't like about it, he said that the government is a revolutionary government. I want to make it clear that the NIA is not a revolutionary government. But these are examples which I think are useful in looking across the landscape of the world, looking across our region, seeing best practices, and when we get to that point where the consultations start, to really see how we can incorporate those best practices. But I want to end by saying to our public that we ought not to be overly dismayed when we are confronted with decisions from the court or otherwise which seek to define areas that had hitherto been assumed or undefined. And the reason I say that is because, again, as the Honorable Mover has pointed out, we have that separation of powers where the courts have the right, we may not always agree with their decision, but they have the right, undoubtedly so, to interpret. And it is true, and I believe the Chief Justice said so in that Ocean News decision, that because you've been doing something all along doesn't make it legally proper. So we accept that. And that is why I think that the public should, when these types of matters come up, actually have some comfort, notwithstanding the chaos and the confusion that the decision might have created for the interaction of the NIA and the federal government and the standing of the NIA to sue or be sued. I think the public should have some comfort that our constitutional mechanisms are in fact working. And that if the court points out a lacuna, whether we agree that there was a lacuna or not, the Parliament has the ability to come here and legislate to fill that lacuna. And that is how mature democracies function. That is how we balance the competing jurisdictions, if you will, of the various branches of government. And so the judiciary says to us that there's a lacuna. We may agree or we may disagree. But the Constitution itself allows us to come here, as we're doing today, to fix the problem. And that, I think, ought to be a lesson for all of those students of constitutional law and theory, for all of those who study government and good governance. That should be a lesson. Because we don't have to go out there and start to cuss the judge and cuss the court and say all manner of things. You see, I tell you, we had the option. Go to the higher court of appeal in England, or come here. The Attorney General, in his wisdom, talking to the legal department in Nevis in their wisdom, they decided they would come here. And this, I believe, is a good demonstration of a mature democracy at work. And so, notwithstanding the challenges, and notwithstanding, as you could tell, my own strong disagreement with this decision, it is yet another example of a democracy which is maturing, and a democracy that I believe we should be proud of. Because at the end of the day, it is not that problems will not arise, problems will arise. This problem arose out of nowhere. We never expected it. But the Constitution and our democratic traditions allow us a formula to solve problems without resorting to any type of untoward or unwarranted activity. And I believe that that is a good lesson for today. So, I perhaps have said more than I needed to, but I wanted, Madam Speaker, to set the tone in a way, pick up from where the Honorable Attorney General left off, and to say that today is a good day, because today we are seeking to solve a problem and put the matter beyond doubt, which brings comfort to all of those who have dealings with the Nevis Island administration, that if for some reason things were to go right, that the fundamental power and authority to sue and be sued has now been preserved. And it is my hope that if anybody were to cite the Ocean Reef's decision to any court, that counsel on the other side would cite the Nevis Island Administration Civil Proceedings Act when it is enacted. I'm, of course, asking for the 2/3. And again, that's belts and braces. We've had a debate as to whether or not it's really necessary. But I'm asking my colleagues on this side to say aye. And obviously, the government side, I'm hopeful, would say aye. Some of them claim roots in Nevis, so I believe they'll understand and say aye. Because we really would like to see this matter put to bed and the position clarified moving forward. Because every country, every island, every government needs a legal certainty in order to engage and to do business. Thank you very much, Madam Speaker.
Thank you to the Honourable Member for Nevis 9.